Gentleman from New York, Mr. Engel, for his 5 minutes of questions.
Thank you, Madam Chair, and thank you to all the witnesses. Let me start with Ms. Alvarado. I want to thank you for your service, first of all, and I was very moved by the fact that we rely on you to keep us safe, but we, in some instances, don't want to give you the opportunity to do what you feel is right with your own body, and I thought that your testimony was very heartfelt.
Thank you.
The abortion issue has always been an issue that both sides take stands and kind of butt heads with each other. My third child was born when I was 46 years old, and my wife was 40. We didn't expect it. And we made a choice to have the child, but that was our choice. I do think that people have the right to make that choice for themselves, and people who feel that abortion is not something they'd consider for moral reasons or anything else, then I believe that they need to do whatever they feel in their heart. But I don't believe that they ought to be restricting other people who may feel differently, and that to me is very important. Now, since 2011, we've seen a tide of Republican-controlled states pass about 450 medically unnecessary restrictions that limit access to abortion care and make it harder for women to get comprehensive health care services. Ms. Northup, can you describe how these state laws and restrictions limit access to abortion care and what the outcomes have been in states that have enacted them?
Yes, the outcome of these state restrictions, many of which are designed to make it very hard to provide abortion services, is that clinics do in fact close. And when clinics close, women have to travel farther. They need to take time off. They need to sometimes make multiple trips and drive hundreds of thousands of miles. And an example of this is the state of Texas, which is the case we took to the Supreme Court in Whole Women's Health versus Hellerstedt. Texas passed an admitting privileges law, which is not medically justified, which the Supreme Court found did not advance women's health at all, because hospitals within 30 miles of an abortion provider can turn down admitting privileges for every reason that they want. Economic basis of the hospital, or that they don't like the provision of abortion services, and they're not going to give providers privileges. And half the clinics in the state of Texas closed. And that was the case until we won the Supreme Court case, and they could never reopen because it had been years of litigation. So it's an example of the devastation, and when those clinics close, it's not just abortion services that lost, but can be family planning services, STI services, and other important parts of women's health care.
Well, how do states justify these laws when they know that so many of these restrictions are designed to limit access to what's really a constitutionally protected right?
Well, I think it shows the fact that they are pretextual laws. They purport that they're about health care, but it's proved in court case after court case that they're not. And again, it's why the American Medical Association and 14 medical groups have filed a brief in the Supreme Court in the case to be argued in 3 weeks to say that abortion is a safe procedure, and the admitting privilege law in Louisiana, just like Texas, doesn't advance women's health.
Well, a number of the state laws and regulations you've described have been struck down by the courts, and most notably in 2016, as you just mentioned, the Supreme Court struck down 2 Texas state laws that required abortion providers to have hospital admitting privileges and retrofit their clinics as ambulatory surgical centers. So could you again tell us why it's critical that we have a legislative solution to address state abortion restrictions instead of just relying on the courts to ensure that the constitutional right to abortion is maintained?
Absolutely. So for those of us who litigate in the courts, it's like playing whack-a-mole. We win a case and the next thing comes up again. After Whole Women's Health, more than 100 restrictions have been passed. The Women's Health Protection Act would provide statutory guidelines that are very clear about what is not permitted, and also a statutory test that would make sure that courts had to follow it. Right now, unfortunately, some courts are not following the Supreme Court's jurisprudence, and that's the case in Louisiana with the U.S. Court of Appeals for the Fifth Circuit, which is why we're back in the Supreme Court again on the same issue we already won. And also, we don't want to necessarily rely only on the courts. Congress has the authority to protect our constitutional rights as well.
Thank you. I know my time is up. Thank you, Madam Chair.
The gentleman yields.